Okay. All right, everyone. So today we're going to be talking about a parent's guide to CPS investigations and family reunification. Just for a brief little overview, this is just going to combine the enforcement process. So like when DCFS comes to you, well, before that, and then when they come to your house, and then and also the period of like when you go to court and maybe represent yourself or have somebody represent you. So those are going to be the two phases we talk about. So. Yeah, so before we...
Is this going to be every week or
It's every month, yeah.
Once a month? But different topics, right?
Yes. So that's why I chose this one, because I don't know, for those of us who weren't here, we talked about basically... No, not probate. It was, what was it? It was about what to say or what to do with law enforcement. So this phase kind of like smoothens, like it transitions to that, because there's an element of law enforcement when it comes to basically this family process here. It should smoothly transition. Okay, so this is why you need to understand it. Yeah, it can happen to any parent. So regardless of income or background, early mistakes can cost you custody or severely limit your rights. So that's why we want to talk about this here today. I remember when I was a paralegal here, there was a lot of cases about that. I'm sure some of you have worked with you on those. So that's why it's just like it seemed like it would be like a popular subject. So here we are. Okay, so what is CPS? CPS is Child Protective Services. That's what it stands for. And it is a broad term used nationwide for agencies that investigate child abuse or neglect. So what I was saying before, DCFS is what we call it in California. That's the agency that they'll call to if there's an allegation of abuse or other things, neglect. Each, as I just said right now, each state has its own agency, name, and structure. We're not going to be talking about what Tennessee calls theirs. And then, in California, it's called DCFS. Plain and simple, there it is. So here's the possible outcomes at an investigation's end. Unfounded, so there's no evidence, there's no nothing that there is any abuse or neglect, which means like it's done, right? No further action. Substantiated means a case is opened and it's assigned to a social worker. And then there's another one, it's like may remain voluntary repetition into dependency court. So just those are the outcomes. So the DCFS investigation stage, it starts with a report being made to Child Protection Hotline, assessed for legal threshold. So it starts that way. Somebody basically just says, there's something going on here, and that kind of gets DCFS to act in some way. There's an emergency response social worker that visits within 5 days and will continue to investigate for up to 30 days. Then there's a decision that's made by them, and that is, can your child live safely at home? If not, temporary placement with a relative, family, or friend is there. But if that's not even a thing, then they'll just remove them, which is... that's from what I understand, they tend to jump the gun a little bit, right? The right to remain, your rights during DCFS contact, like I said before, very similar to law enforcement, the law enforcement agencies we were talking about before, police, the feds, federal, FBI, ICE, the DEA, right? So it kind of falls under that area of law enforcement, so you get the same rights as you once were. Oh, and by the way, if you did miss that workshop last month, that's the reason I'm recording. You can find that one on YouTube. Not trying to advertise or nothing, but you can. That's why it's there. There you go. And so so it's like I guess it's for everybody in case you miss it. There it is. Attendance is not mandatory in this class. Okay. That's an aside. So you get your right to remain silent and consult an attorney. That's your Fifth Amendment right? We all remember this? Your right to refuse entry without a warrant unless there's immediate danger. I guess there's that pseudo category because when there's a report, I guess, I'm not sure. I'm not completely sure if that satisfies probable cause. I'm sure the courts have decided it, but it's worth considering. Maybe they have probable cause already when there's a report made. Nonetheless, you should ask if they have a warrant or probable cause. You have the right to see the allegations in writing. So whatever they're alleging, you have the right to know that. You get to document all your interactions. That's what most lawyers are going to recommend you do. And you can access your assigned social worker or an attorney or a parent partner as well. So just some things to keep in mind. Here's some common pitfalls. Volunteering extra information without knowing the consequences. So writing those interactions down. Contacting an attorney when they ask you a question that is kind of in that, okay, am I giving too much information? Even something small can like slip out and there's no context behind it, they'll use that against you. So that's why it's always good to make sure you're staying as quiet as you can. Preferably you don't speak without an attorney present, or missing deadlines for services or court filings. That can negatively impact, needless to say, that can negatively impact your case if you do that with a judge. When to petition. So we're going on from the DCFS, or I guess I think there's some more slides about that, but when you're gonna petition, it's gonna be after removal and case plan completion. So this is after the DCFS phase. You petition the court for visitation, whatever it is that you can, you'll mostly qualify for visitation at the bare minimum, and custody. You also want to petition when the circumstances have substantially changed. We'll get into this a little bit, but once you get above that visitation phase where you're eligible for more custody like joint, full, they're gonna wanna see some substantial change in your situation if there's some sort of reason why they're not giving it to you. And also if you're seeking to modify an existing custody order for obvious reasons, whether it's you're the better parent and you gotta tell the court, I'm the better parent, so I need to get that custody, right? Best interest, right? Best interest, I don't know if you remember last time, but we talked about legal standards. Probable cause is one of those things. It's the easiest one to meet because police, I guess, have to do their jobs, right? Best interest of the child has to be one of the most confusing legal, it's one of them. It's one of the most debated legal standards. So what consists of it generally is gonna be your child's age, your child's health, their emotional bonds to each parent, stability, parental capacity, and safety history. The way I kind of see best interest is that the more of these you can meet, the better your outcome is. There's no guarantee, but the most you have, the best situation you can give to your child, the more likely they are to rule anything in your favor. So that's been the commonality I've seen, was whoever meets these the most gets whatever order they need. So full custody, they get it. Yeah, that's the better case. They consider age, for example, right? They consider, I think it's 14 or 15, where they give deference to the child's wishes. So if they choose to be with mom or they choose to be with dad, they'll consider that. It's not guaranteed, but they'll consider it. Their health, who's paying for health insurance, who takes them to all their appointments. Emotional bonds, who do they choose to be with more, because, and that's the tricky thing, is their bonds, but they should have both, obviously, but sometimes, we know those kids who have more of an attachment with one or the other. Stability, so who, that kind of goes under, health kind of falls under that, I would think, like who takes them to school, who satisfies their needs the most, right? Who's consistent, that's stability. Parental capacity, I feel like stability and that kind of, they're basically the same thing, who's able to do that. And their safety history, which one is more safe, or both, whatever it is. So that's a little bit of best interest in a nutshell. Filing the petition, I don't know if anyone here has been to a court but the clerks, yeah. And are the clerks usually nice to you? No? From experience, they've always been good. They've always been helpful if you're, if you've been confused. They'll tend to tell you which forms you need to file. So they're a great resource, and so is the self-help section or office. Usually they're found in the courts. There's some, I think it's free. They're free self-help. Yeah, you can find those. And then that's like one step. The other step is gathering the strong supporting evidence. Let's say, for example, an ex of yours, the baby daddy or baby mommy, whatever, the baby mama, whatever it is. I do both. Let's just say the other person, whoever it is, they have an alcoholic history, right? And they just go, oh my God, like I'm so hungover last night. Like you have that on text, screenshot it, and then keep it as evidence, right? It's that easy, I promise you. That's a little bit about filling the petition. Notifying the other party, so you got to file the proof of service. That's one form you do have to file with the in the packet. And what that basically is that's your service form. That's to certify that you serve the other party, and you do that by just getting somebody who's 18 or over, not yourself, and literally anybody but yourself that's 18 or over. They serve them. That requirement is fulfilled.
Or you can have the sheriff do it.
Yeah, you can have the sheriff do it. That's right. This is so right. I forgot to mention that the sheriff will do it. Thank you for that. Yeah, presenting your case effectively. So, yeah, we organize the evidence. We prepare the parenting plan because that's another form. Which vacation days you want, what weekly schedule do you want? That's what it is. That's what it's all about. That's the parenting plan proposal. Maintain courtroom demeanor. So when you're in court, actually I should probably recycle that. Basically just goes over what things you should consider when going to court, right? So like the most discussed one is dressing, kind of like in a professional manner. That's a good word for it.
You were going to like an interview or something.
Basically, yeah, that's a good one. I don't either. So let's go a little further. After the hearing, right? So you understand and follow the court's orders. So here's the thing about what happens when when a judge makes an order. Very important that you follow it no matter how it goes, because then the other person they have the opportunity to file a contempt of court motion, and then that puts you in even bigger trouble. So you do want to follow those court orders, because things will just go even more south for you. Steps to take. Yeah, so usually for these kind of family matters, they'll leave the case open. They won't close them. Well, I mean, I guess they technically do, but they leave it open for you to come back, like run it back and petition again if needed, because you should be afforded that opportunity to petition once again if things change.
How long does that last?
The court order, or
when you said that they close out, but it's left open in case there are circumstantial changes for you to come back and modify it.
Yeah.
Is that
like, are you saying
indefinite amount of time that you can go back and petition under that case?
It depends, because sometimes that's a very good question. Because sometimes they'll require you to take parenting classes, so that would be the duration of time that they'd have like you wait. But I think they leave it open just in case they did make a ruling that wasn't very beneficial after all. Right. Like, say after the ruling something tragic, I guess that's the best way I can put it, then I guess that would give you grounds to refile.
Right. Or appealing?
Honestly,
would that be at the 388A for the appeals?
Honestly, I'm going to be honest. I don't have the most experience when it comes to appeals. But that's what I mean is that like
I'm asking for her.
no,
I'm
like
trying to figure this out.
no, we've never done like when we worked here, we've never done like appeals as basically as I can that can be applied to anybody really. In these dependencies or custody disputes, that's why I meant like they're open, so that you can refile. So I don't know if appealing in that sort of case would be like any more beneficial or not. It's just, I don't know. I leave that to the lawyers. That's why I would, when it came to like advanced things like that, I always delegated it to my supervising attorney at the time.
Right. And a dependency attorney
yeah.
is a lot different than a family law attorney.
So I guess we'll keep moving on. Your resources. So there's legal aid and family law nonprofits. So there's some there's some clinics that'll help you out for a discounted price or maybe free. There's local court self-help centers that we talked about. There's the official self-help website listed here, right here for the screen. And then what I found out when I was doing, oh, this is for the court self-help. You don't you don't need to screenshot if you want. I can give you the YouTube. Not trying to advertise again, but you take a screenshot and then it's clear. So and then what I found out when I was doing research for this was pretty awesome. So it's called CASA, and that's the Court Appointed Special Advocates. Basically what that is that's a group of, they're essentially interns, and they help you reach best interest. They're a group that the court gives deference to when they're kind of like attorneys in a bit, where they'll personally vouch for your best interest. That's what they're trained to do. So very important resource when it comes to meeting that best interest.